It's not in the face! Thank you.
Hello and welcome to Hey, Not the Face with your host, John Nash, and your producer, me, Steffi Haynes. And today we are going to look at the Education and Workforce Committee meeting that happened yesterday and all of the proposed changes and what exactly happened. We are also going to talk about an emergency ABC meeting that happened just a few hours ago. And we're going to get John's take on all of this. And we also have some antitrust updates to lead off the show. But if you want access to all of these things, you're going to need to subscribe with your money. Pick up a paid subscription so that you can have access to the entire show, not just half of it. Now, John, you have been a busy bee over the last 2 days. Are you excited for all of these things that you have had your ear to?
Oh, yes. I've been really busy. It's been an enthralling day. As just before we started recording, the show was almost interrupted for my mom who needed her medication, but now we are focused. And I have been, don't tell my boss, but I've been skipping a lot of work to cover hearings in Congress, ABC meetings, a lot of stuff happening in the world of combat sports, which we are going to talk about today.
You know, I have your boss on speed dial. I'm going to call him up and tell him.
Yeah, please don't. Yeah.
All right. Well, we have a lot of ground to cover, so I'm going to go ahead and kick us right off and ask about new filings and updates to the UFC antitrust cases.
Well, there was. We did, surprisingly, we didn't have any updates last episode, but this episode there was an important filing. There were several documents filed by the defendants in the antitrust case. There was also a few motions to seal, which we discussed a couple weeks back, by the plaintiffs about information that had been in some documents that they didn't want in there. And it really doesn't impact the case much. So I'm going to skip that. I'm going to focus on the more important thing, which was files from the defendants. And this is for the Johnson v. Zuffa case, although technically it applies to all of them because all of them are doing discovery at the same time. And it pertains to the defendants. And it's their efforts to challenge the January 6th of this year discovery order amid allegations of evidence spoliation. So this was filed January 20th officially and includes a motion to stay discovery order. Defendants are moving to stay the court's order pending resolution of a Ninth Circuit, what's called a mandamus petition. It's basically an appeal to the Ninth Circuit that they filed. The order allegedly compels disclosure of privileged attorney-client communications and testimony from UFC executives Dana White and Tracy Long regarding document preservation. So attorneys from the firm representing the defendants, Dunn, Isaacson, Ray, I think Campbell and Williams, and then Latham and Watkins, man, they have a lot of high-priced lawyers working for them, represent the defendants. They emphasize irreparable harm from forced revelations. And so then they also filed with that the mandamus petition, which is the motion in support of their stay motion, which is the filing they did with the Ninth Circuit. And then they also filed a petition for writ of mandamus. This core document petitions the Ninth Circuit to vacate the order, calling it unprecedented and erroneous. It argues that the order pierces privilege without sufficient spoliation evidence. So the gaps in which is the gaps in White and Long cell phone data. It violates the First Amendment by chilling future communication and exceeds Rule 3070 sanctions. So the petitioners seek reassignment to a new judge, citing irreparable harm and no adequate appeal remedy. So that's potentially huge because one is they're claiming that this testimony, the judge's orders regarding the spoliation goes well above and beyond what he should do. And for that reason, there should be a stay of any more disclosure. And they're also asking for a new judge. And as we've seen how Judge Boulware is operating this case, That would probably be the biggest thing. So potentially massive. We will see what's going to happen. I am still scheduled. I am still booked to go to Vegas February 4th and 5th for the testimony of Long and White. I'm not certain they'll be testifying. Now, it's possible that the judge or the Ninth Circuit even shoots this down, but based on this, they seem really adamant about not testifying. Will they, even under court order, show up to testify? It seems like a reasonable question to ask right now. And as a layman, I did have to ask some of my legal expert buddies about this petition and their general sense. Now, they are not involved in the case. They're not fine-tuned to all the intricacies, but their general sense, it seems kind of like a last-ditch Hail Mary on the side of the defendants, the UFC, to keep Dana White from testifying and keep the judge from getting access to any of the spoliation material or ruling against them on the fact that they didn't have this material. So again, their words was it's kind of a Hail Mary. Let's see if that's true. Maybe they have a stronger case than I thought, what these people told me, but we will have to wait and see. But this could potentially be pretty big impact on the case if the Ninth Circuit picks up the case, and if the Ninth Circuit petition, if it grants their appeal to them. So again, we will have to wait and see what happens.
All right, that sounds pretty big. So we're going to move on, though, because again, everything that you've been covering for the past 36 hours is going to take precedence in today's show. So we're going to just dive right in. And the first thing is can you explain what took place yesterday in the Education and Workforce Committee?
Well, in the House of Representatives, that's the Congress, there's the lower house, the House of Representatives in the United States government. They divide bills and legislation into committees. So a committee is where some of the members, the members of Congress, the members of the House of Representatives are split into various committees. And so before the full House gets to look at it, it's introduced into committee and the committee looks it over. And so what happened yesterday is the bill had already been introduced, and yesterday was the markup session where potential amendments, changes to the bill are introduced. And they introduced, before even the start of the session, they basically introduced a whole new version of the Muhammad Ali American Boxing Revival Act that had numerous revisions, changes, edits, removals. So it's almost a completely new bill. Even before the start, they still had to vote on if they agreed with those changes, but that was done, everybody was given that ahead of time to review, so they didn't really discuss that. And then members of the House of Representatives each gave kind of a statement on their position and introduced other changes, and then they ended up voting on it. So that's the process of yesterday. It was the process of changing the previous bill, the original bill that had been filed, that some people might have seen. In fact, we will put in the body of the Substack here. I will upload the amendments because I don't think they've been uploaded yet to .gov. So I don't know if the public has seen them or can see them, but they were sent to me from the House when I emailed them about it, and they sent me so it's not like I have secret information, but we will upload it so other people can see these changes, amendments, and the new version that's being pushed forward now of the Muhammad Ali American Boxing Revival Act.
What changes were made to the UBO section of the bill?
God, I'm glad you broke it apart because there's a lot of changes. And on the UBO section, there was a couple changes. Funny enough, the UBO is the bigger, I guess, the more important portion of the bill. I guess the part that gets the most attention. And there were fewer changes to that than I saw on the other parts of the bill. And the primary changes to the UBO, well, one thing we should know, what wasn't changed. The big thing that wasn't changed in the UBO was it did nothing about that section that said you're in compliance with the rest of the bill, with the rest of the Ali Act, if you are able to operate as a UBO. That part was left in, and what that does is it lets people, basically gives them a waiver on all the protections in the Ali Act. And so that was kind of that's obviously the primary reason for this bill, and the fact that it's you would imagine, because TKO is the major driver of this bill, let's be honest, they're the ones pushing it. You'd imagine that they would make sure that that's left in, and it was left in. The other parts of the bill, the other two ones, is one on physicals and medical examinations, and or I should say for the UBO sections, and that's they struck a lot of the text and stuff out of the bill. I shouldn't say text, that's the wrong term, I guess. They stuck a lot of the definitions changes out of the bill, which makes it easier to read, and that was helpful. But the other part is they added some medical changes and drug testing changes, and a big part was the drug testing changes. They just added a lot more oversight, which I think is kind of positive. They added a lot of oversight from the ABC to look over that they have to report the changes. The ABC, they have to report to the beginning of the year, or I can't remember the beginning of the year, at some point, what drugs they're going to be testing for. Because if you remember, we had Kurt Emhoff on the show, other people, they talked about how kind of vague the drug testing policy was and open-ended, and how much authority it gave to the UBO, and the UBO would have the right to not conduct any test, to not pick their whatever they wanted to use for their tests. And this, they have to post all this in advance. There's a lot of oversight on that front. And then they had another section they added with an additional ambulance that must be provided. So that was the big changes. Really, that's really the big changes to the UBO is that they had a section on the doping requirements, the drug testing requirements, which, they clarified a little bit of that, and then had some enhanced medical inspections, namely that there's ambulance, namely more physicians, but not much on the UBO. The UBO portion was the one that was less touched than the rest.
Let's go to Section 4, Industry Standards. What changes did they introduce for medical examinations?
Okay, this one was fairly big. They added a whole section of medical examinations that would be, I'm trying to phrase it in a way that makes it easy to understand, because it is extensive, the amount of medical examinations changes they offered. They want you to do a ton of tests. They added in there. They had a bunch of I should say, and for industry standards, it should be noted, this applies to everybody. This is the most important part. For the section on the industry standards, this is not the UBO section. This is from now on, we're going to be talking about this section that applies to everybody in boxing. So if you're a promoter, and I do know a few small regional club promoters that listen to the show, you're going to want to pay attention to this. If you're an athletic commission, association of boxing commissions, you might want to pay attention, because these are some of the changes that I believe some of you guys were caught off guard about. Maybe not this one as much as what comes later, but this whole section on the changes to boxing industry standards is the part that you're going to want to pay attention to. So on the health and safety boxers, they amended it and added a whole section on the physician examination, on the minimal medical requirements, the validation of the licenses of those conducting the physicians. They had a required examination, so you have to get a complete physical examination, including blood work, every 1 year. They had some of this before, but now they laid it out with a lot of more strict dates and deadlines on this. So going through it, required examinations, you have to get a complete physical examination, including blood work, once a year, dilated eye examination at least once a year, heart examination once a year, antibody tests every 6 months, brain health examination for boxers age 40 and older, an MRI scan and an MRA of the brain. And for boxers under 40, an MRI once every year, which I think is much more than a lot of states currently require. In the case of female fighters, a pregnancy test 14 days, I think, before the test. And then they have some sections on the physicians, their licensing, and a whole bunch of things like that. Now, I don't think these are massive changes except for the amount of testing, but this is all new.
What did they change about the insurance coverage?
Okay, this I think caught a lot of people off guard, because if you remember, most states before the new bill, before the Muhammad Ali American Boxing Revival Act was even introduced, every state had their own minimum requirement. New York had the highest. California had one of the higher ones. And they introduced an insurance policy about $25,000. I shouldn't say about, it was. You have to provide a minimum for each boxer, health insurance, that is, of $25,000 in medical coverage for any injury sustained in the match. Now they've changed that. You now have to provide a minimum of $50,000 in medical coverage for any injury sustained in the match, plus $15,000 in accidental death coverage for any fatality arising from such a match. And so that's, they've doubled the amount with the amendments that they introduced for this bill.
Did they change the purse minimums?
They did as well. As we noted last time, the previous bill was $150 for each round for each boxer. That was the minimum. And now they've upped that from $150 to $200. Now, I've heard people say that because California had asked for this. If people remember, if they were on that phone call with Andy Foster and the Athletic Commission, the board in California, and they were discussing this minimum, how they said they wanted it to have an inflation adjustment. And I'd heard some people throwing that around that it's going to be inflation adjusted, and that was inserted in the bill. But I'm looking at the what's been pushed forward. This is the version that came out of committee. I'm looking at this one, and the minimum pay to boxers is for $200 for each round, but not inflation adjusted. In other words, will not increase with inflation. So that change that the California State Athletic Commission asked for, and that some people said was in there, I do not see it in here unless it's buried in some part I didn't see. But I don't see it here where you would think it'd be the part about the minimum payment to boxers. And so this is, for a lot of states, this is probably a big increase because most states don't have a minimum. Right. This is just for the only states that have a higher minimum than this. I can't remember if New York has a higher minimum. I think theirs is only $100, but it might be $150, $200. This is the minimum that California has. So now they're going to say every state will have the same minimum for $200 per round. So in 4-round boxer, which is the minimum number of rounds you do in boxing, you would get $800, which is not a lot, but a lot more than what, I shouldn't say a lot. It's more than what some boxers were getting because, again, when we looked at the total payouts, there is like a small 5-10% of boxers getting less than that in each match around the country. And so this would increase that amount. And so you'd basically up the bottom for, still, even though it's this much, it'd be several hundred fighters per year, probably seeing an increase. And there'd be an end to what's called the $1 contracts, which are common in MMA, not common in MMA as much, common in boxing. In MMA, they just make the fights amateur fights. That's how they get around that.
What did they add into the bill about the number of titles?
Well, this came out of left field, actually. This is kind of surprising. And this one I love. And again, listeners of the show might know why I love it, is because this is something I have suggested that the athletic commissions do on their own. And I've also said this is the type of changes they should be looking at if they're going to amend the Ali Act. They should be tackling the problems with the sanctioning organizations instead of introducing the problem of the UBOs. And so what this changes, it calls for singular titles. It says a sanctioning organization or unified boxing organization shall award only one championship title for each weight class. They have an exception for interim titles. Interim titles, a sanctioning organization or a unified boxing organization may not award an interim champion title except in the case of an injury or illness to a reigning title holder, refusal or inability by the reigning title holder to defend his title, or for reasons beyond the control of the boxer, including inability to travel. And so, as we all know, the WBA is probably the worst offender of this. There are multiple titles in boxing. There are the regular champions. There's the silver champions. There are the super world champions. There's, if you go through all the different sanction organizations, there are numerous various champions. And they're saying for each weight class, you can only have one title. Now, I have some gripes with this. because I think it's a little unfair to say you can only have one title. I think it should say you can have one world title, because regional titles are kind of important to some parts of the world. They don't have many world champions from their part of the world, but like, in the UK right now, the British champion, although that's controlled by the British Board of Boxing, but Asian champions, Caribbean champions, those can be meaningful to some boxers, because it has a marketability to their region where they have importance because they have very few champions. And so maybe they should have just said, you can only have one world champion, and then be more stringent about what can be done with like the ratings or things like that. But I'm not going to complain too much, because I think this is great, because one of the things hurting boxing has been that these sanctioning organizations have been printing way too many titles. I should note too, under this rule, if this ever got expanded to MMA, the UFC would be in trouble, not really in trouble, but they would have to drop the BMF title, because that would not be the one singular title in that weight class.
What changes did they introduce regarding drug testing?
Well, this is a pretty big one. I think it missed a lot of people when it was first introduced. Obviously missed the people that put it in the bill. They added to a section of the Professional Boxing Safety Act. So again, this affects all boxers. This is not in the UBO section. This is in the Professional Boxing Amendment, the Safety Act of 96, Section 306. What they amended is they added a procedure that ensures drug tests shall be administered for any title bout. So any title bout you will have to have a drug test for that title bout. And at random for all other bouts, provided that tests are administered for not less than 50% of such other bouts. And then such drug tests shall screen at a minimum for any substance listed on the most current edition of the World Anti-Doping Code, the prohibited list international standard of the World Anti-Doping Agency, except that a boxing commission may elect not to screen for such a substance if the use of such substance is not prohibited by the state in which the match is held or the tribal organization. And so then they add some other, consistent standards and things like that. After that, they add a whole section about the development of standards amongst the boxing commissions, how the ABC, in partnership with the Associated Ringside Physicians, is well positioned to identify the policies. So they put a lot of responsibility on the ABC towards this drug testing protocols and things like that. But the drug testing is, I'm sure some people will ask, what's the big deal? Drug testing is great. I'm sure we'll go into deeper. But that might be the one that I think caught people's attention the most coming out of the hearing.
What is the concern for club shows from these last few changes?
Well, I hinted a little bit that a lot of people were concerned about the drug testing, but if you add it to the other ones, the big concern is basically, can they survive doing these changes? If you go back, just go through them all. I talked to a bunch of regional promoters, and a lot of them had no problem with the $25,000 insurance coverage. That's a cost. It's a little higher maybe in the state they were, but that's a cost. It's a set cost. They can budget for the year. It's not going to hurt them. But some of them were like $50,000. That adds a lot of price. That adds a lot of cost to my shows. And then on top of it, a few other ones were concerned I don't think they had a problem with $200 a round, but when you have to do that on top of other things, again, that's an additional cost. So they had to be concerned about that. But the one that they really, the $25,000 to $50,000, some states, some promoters had an issue with that, said it would hurt them, but that wasn't universal. But the one that really caught everybody is the drug testing one that we just said. And the reason why is, well, that's not required right now, right? The club shows do not have to do drug testing. And so I'm sure, again, a lot of people will be like, well, isn't that good? We should have drug testing. We can't have these cheats. The question is, who's going to pay for it, right? Because if you read that bill, first of all, it says that you have to do it for all title shots. Well, okay, does that include if they do not get, let's say it passes with this, but doesn't pass with the one title per sanctioning organization? Well, what about regional belts and stuff? You have these minor titles. Do you have to do it for those events? What if you have to do 50% random? That means half of all the card has to be tested. That's a large number. If you have a 10 match card, that's 10 fighters that have to be tested. Well, if you look at the cost, my understanding, asking around, is that the cost of these tests, these type of world anti-doping tests, are somewhere between $500 to up to $900 per boxer to do those tests. And so you are talking, that's a sizable cost. Now, the athletic commission's not going to pay for that. They're going to put the cost either on the boxer, and this bill doesn't, the boxers aren't going to have the money, or the promoter. Well, that adds up. You're talking thousands additional for club shows that don't make a lot of money. On top of that, as I was told, there is one place in the world, in the United States, that basically does these tests, Utah. How are they going to handle that kind of load of tests? And so you're going to be overloaded with them, so the tests are not going to be completed. The cost is going to be prohibited, and numerous, and I think even on Twitter, you'll see some club show promoters talking about this, but other ones I've talked to, I know athletic commissioners that I've talked to, the same concern. This could be almost a death knell to a large number of promoters. Remember when the UFC went to New York and they legalized MMA in New York, and they drastically increased the standards that you had for insurance, that large numbers of promoters disappeared because they just couldn't afford to operate in New York. Now, some people might say it's worth that because, we want better health and safety standards for fighters. But at the same time, if you want any sort of club shows where guys can get their feet wet, get some experience, that would be terrible. And so you're talking about, I know for a fact that several promoters said there's no way that he could function if he had to do all three of those things because the added cost. Now, I think the least of his concern is the purses because most fighters already make more than that, and that's never been a concern. But you put that slight additional cost on top of the cost of the new premium for the insurance coverage. And then you throw in the cost of them having to pick up the drug testing, and you add those together, and suddenly what they were barely squeaking by when they're doing the shows, they are losing money. And I'm sure that is common amongst numerous promoters, club promoters. So that is the big concern about those last three things. And I don't know if they didn't talk to anybody. Before we recorded this, I was watching the Sports Law Association webinar. Our friend Jason Cruz over at MMA Payout had me watch it so I could, report on it, which I did on Twitter, X, and Pat English had talked about the efforts they went to when they did the original Ali Act, how they did research, how they invited people in to give their experience, to share what the impact of these changes would be, that they kept out lobbyists. And because of that process, you didn't have something like this where you're introducing a section of the bill that might actually hurt the industry you claim you're trying to help.
The effective date was also changed. What does it say now?
Yeah, I noticed this as well. The right now it's the Section 5 effective date application. The amendments made by this act shall take effect on the date of the enactment of this act, and shall apply with respect to boxing matches that take place on or after the date that is 30 days after such date of enactment. Now, how is this different from the previous version of the Muhammad Ali American Boxing Revival Act? The difference is, if you remember, the previous one says this amendment becomes is enacted 30 days after the bill was enacted. Here it says the act shall take effect on the date of enactment of this act. In other words, on the signature, and then will apply to boxing matches 30 days later. Now that sounds like, okay, that's 6 of one, half dozen other, but if you pay attention, that's actually slightly different. What they're saying, and it's obvious, I think TKO had someone insert this, because they want this bill in place as they're running their Zuffa boxing events. Now, it only applies to matches, but there are other aspects of the bill that apply to stuff that takes place outside the ring, right? And so what they're saying is they want those parts, probably stuff that maybe has to do with, some of the protections in the Ali Act that they want some immunity over, things like that. They want those put in place immediately upon signing, which is 30 days before that. before it says the date of enactment for those events. So they want to cover their ass as quick as possible. And at least that's what it says to me, that they want this bill in place and the protections it offers them as soon as possible. And we know that's probably the case because word on the street, Luke Thomas has said this, other people have told me, is that there's been a push that the administration basically told Congress that this is something of a priority for them. God, which is amazing. Actually, one of the congressmen, Scott, of the Democrats brought it in that the Republicans seem intent on getting this passed as soon as possible. Never mind that there's probably more pressing concerns to the public. They seem intent on making this a priority.
What were the amendments that Ilhan Omar read off during the hearing?
Well, this is another, there's some interesting changes, and we'll go through. I'm not sure these are her amendments. That's the strange thing, because I saw everybody saying these are Ilhan Omar's amendment changes. But if you look at the document that was filed that has these amendments, they are amendments to the amendment in the nature of the substitute, which refers to the complete new version that they submitted, offered by Miss Stevens of Michigan. So it's a different Congress member, according to this, that these bills. Now, I missed maybe what Omar said. Maybe she was reading it off on behalf of Miss Stevens, who couldn't be there. But the changes they issued in this amendment, either by Omar or by Miss Stevens, is required contract provisions. They claim, and they actually cited the UFC example in this, they claim that these UBOs could eventually be used to monopolize the sport, basically, use coercive contracts, things like that. And so they wanted some changes to give the fighters some protections. And some of them I really like, some I don't. So we'll go through a few of them right here. So it says, during the 30-day period on the last day of a contract, such contract, the boxer may not be prohibited from communicating with another UBO or promoter. I like this one because, as you know, on a lot of MMA, boxing as well, contracts, at the end of your contract, there's an exclusive negotiating period, right? Sometimes can be several months. And then there's a matching right. Well, what this says is 30 days before the ending of your contract, you can actually go and communicate with other promoters. Well, and that way you can actually get a feel for what kind of interest there is in you, right? And so you can use that to your advantage and then negotiate with the UFC, and then also decide, do I want to, because as we've seen in the past, promotions like the UFC, they will say, okay,
You mean Zuffa, like you would negotiate with Zuffa with these contracts?
Oh, yeah. Negotiate with Zuffa. Yes, you negotiate with Zuffa. But as we've seen with the UFC, when people negotiate with them, is if they'll give them an offer during the exclusive matching period, and if you turn that down, then they might waive the exclusive match but they'll no longer negotiate with you. This is before your last fight, because the contract ends with your last fight. Reading this the way it reads is you could go talk to another promoter before your contract technically is done, find out their interest in you, and then fight your last fight, get the UFC's offer, knowing full well that there is a good offer for you out there if you turn it down, or accept and then that way the UFC cannot give you that take it or leave it deal, because there's an offer out there. And so that would be very helpful, I think. And then it also includes that such contract shall specify the minimum payment that such boxer will receive for participating in a round of a boxing match, which shall not be less than $200 per round. And then they have to, this is the other part they have to do. They also have to arrange that such boxers fights in a minimum of one boxing match every 6 months. Okay, now this is common. I like this one too a little bit. It's not groundbreaking because most boxer contracts, they're required under the Ali Act to include minimum number of bouts per year. And so, but again, if you use like a UFC comparison, for MMA, this would probably be a better addition, because we've talked about in the past, UFC is not required to give you a fight every so amount of time. Boxing contracts technically are, because you have to have a minimum amount of fights per year as part of the Ali Act, the original Ali Act, so people don't get confused. But in MMA, we don't have to offer you a fight. When it says, it's a 5-fight deal in over 20 months, And Dana White will always say, offer you 3 fights a year. Well, that 5 fights over 20 months is really your first fight. And then you have 20 months to get the next 4 fights, as we've discussed in the past when we talked about the contracts. And so technically they could wait more than 6 months. And then just to make sure that, based on, I cannot remember the exact amount of time they have to give you between fights, but I believe it's only a couple months. They could crowd the last 4 fights in the last 12 months or so of the contract. And that's the way you can starve fighters out, punish them, whatever. This, they would have some consistency, having a boxing match every 6 months. Again, more applicable if it was MMA was addressed by the bill. I don't think that's that big a deal. But here's the addition, the second part of this, which I think makes it a bigger deal.
To access the bonus content of this episode, you must be a paid subscriber. To do that, go to heynottheface.substack.com and subscribe today.
It's not in the face! Thank you.